Perfect. So I'm going to start with a little bio about yourself, Mr. Fisher, and then we will get into your presentation. So Barry Fisher is a mediator and arbitrator in Toronto. He was called to the Ontario Bar in 1979 and has been an ADR practitioner since 1987. His practice focuses on both labor and employment law matters. He is one of the most often chosen mediators for employment law cases under the Ontario Mandatory Mediator Program. He is the author of the Wrongful Dismissal Database, an online database published by Carswell, designed to assist lawyers and human resource professionals in determining reasonable notice. He is a distinguished fellow of the International Academy of Mediators, an organization of leading commercial mediators from around the globe. Barry is listed in the Best Canadian Lawyers in Canada from 2008 to present. In the category of alternative dispute resolution, he has also been referred to as the leading member of the employment bar in the Canadian Legal Lexpert Directory. Barry is a frequent presenter at the seminars and educational courses on issues relating to employment law, labor law, and ADR. He is the past chair and current executive on the alternative dispute resolution section of the Ontario Bar Association and the current executive on the labor and employment section of the OBA. He is also a member of the Ontario Labor Management Arbitrators Association. Barry is the recipient of the Ontario Bar Association 2011 Award of Excellence in the Alternative Dispute Resolution and served as co-chair of the Law Society of Upper Canada's Employment Law Summit for 10 years. Barry is an executive committee member of the Canadian Academy of Distinguished Neutrals, recognizing the top civil ADR practitioners in the nation. Very incredible resume, and we're so happy to have you here. So I'll let you take things away, Mr. Fisher.
Okay. All right. So the topic is pretty broad, so I've kind of started, but if there's something, obviously if there's more, if you have questions or you want me to talk about something else, just speak up. As I say, I encourage you to ask questions or make comments as we go along. I'm not sure, I don't know your very background. I think a lot of you are undergrads or law student wannabes, a couple people in law school or beyond. So I'm going to start with some stuff which may be basic. I won't spend a lot of time on the basics. We use the term ADR. We've got a little sloppy with it these days because a lot of people use it as another word for mediation, but mediation is just one component of ADR. There are many, many components of various degrees, but they're really, the two biggies are arbitration and mediation. And the way I always explain arbitration, the difference between arbitration and mediation is pretty fundamental. An arbitrator decides the issues like a judge in a courtroom. The joke I pull about the differences between an arbitrator and a judge is if you offer to pay the judge, that's called bribery and you'll go to jail. If you don't pay the arbitrator, you'll be sued civilly for not paying his or her fee. But so arbitrator, think like judge. You hear evidence, apply the law, and make a binding decision, which is in fact under the Arbitrations Act enforceable as if it was a court judgment. Mediation is not a decision-making process. It is the neutral trying to bring 2, 4, 5, 10 parties together to see if they can arrive at a mutual settlement. In most employment cases, which I'm going to focus on because it's really all I've ever done, there are 2 parties, the plaintiff, which is usually the dismissed employee, and the defendant, which is the employer. There can be other parties, insurance companies and stuff, but in the overwhelming majority of cases, it's employment law. Somebody's being fired and they're seeking termination or dismissal damages of various sorts. So I started off as a lawyer in 1979. The year, I'm sure none of you were born then, I just make that one comment. It was a good year. I became a member of the bar and Khomeini took over Iran, but the two events are quite unconnected. I started off, funny enough, I thought I was going to be a tax lawyer. When I articled at a large firm It's called Stikeman Elliott. And I thought I was going to be a tax lawyer until I started doing it and realized that wasn't for me. But at that time, employment law, which funny enough was not called employment law, it was actually called master and servant law, if you can believe it. That was the term used. It was just starting out. And I was lucky enough to latch on to a practitioner, one of the earliest practitioners in employment law. And I was not asked back to that law firm, one of the best rejections that ever occurred in my entire life. So I joined this associate who was not allowed, was refused partnership. So the two losers, three of us actually, three losers left the firm at the same time and started our own firm. And we started doing more and more employment law. At that point, it was the one nice thing about employment law too, which is a little different than labor law, which is the unionized workplace, is employment law. Lawyers often act for either side, obviously not in the same case, but you get a healthier outlook on an area of law, I believe, when you are not rigidly representing only one side. So I had early exposure to both how to represent individuals, plaintiffs, and defendants being employers. I first became an arbitrator well before I was a mediator, and it was very happenstance, frankly. I happened to be over at the offices of a gentleman who's now passed away, Marty Teplitsky, who is a well-known labor arbitrator. And I had a case before him, and he shared space with another well-known arbitrator, Owen Scheim, who's still. I had appeared before Mr. Scheim as counsel before a tribunal of which he was the chair in a long, protracted case. And I met Mr. Scheim in the hallway, and I still call him Mr. Scheim, even though I've known him for 40 years. And he turned to me one day and said, "Barry, yes, Mr. Scheim, would you like to be a vice chair of the..." And I said, "I would be honored." He said, "Fine, I'll send you a letter." So what did I do? I went back to the office. What in God's name is the GSB? What did I just sign up for? Anyways, it turned out to be something called the Grievance Settlement Board, which is a labor arbitration panel for the provincial civil service. He chose me. So I've been doing that. I started that in, I think, 1985. That started my arbitration career, and I'm still a vice chair of that particular tribunal. So that was my first introduction to arbitration. And it was quite an introduction. In those days, ADR, labor arbitration, was primarily a three-panel board. Now, unlike a court that would have three neutral judges in labor arbitration, when there's a three-person board, there was the chair, the neutral, me, and then there was an employer nominee and a union nominee. And their roles were really secondary advocates. It's rarely used now, that model. Now most arbitrations are what are called single panel. Anyway, so I started doing arbitrations, and I had done some litigation at that point. I had had my share of trials, I guess. And what always bothered me about trials was the stone-faced judge or the stone-faced arbitrator who would come in. It was usually a he. And they would come, they'd say, "Good morning." And that was all they ever said. And at the end, they'd say, "Thank you very much. You'll be hearing my submissions." There was very little back and forth. So quickly on, I became an arbitrator, I just frankly didn't have the patience for it. So I became more interventionist. I asked more questions. I directed counsel as to what I thought would be helpful and what would not be helpful. And in the beginning, I encountered some resistance to that. But I just actually wanted to know what was going on. So that naturally led to, in labor arbitration, there's always been a tendency to try to resolve matters. We didn't have fancy names for it, that's all. And I found that when I pulled the counsel, in those days, you pulled only the lawyers aside, that I enjoyed and found more satisfying the ability to get the matter resolved than going away and writing a boring award, because I also don't like writing. Being a mediator flows partly from just being lazy, because it's much easier to be a mediator than an arbitrator, frankly. Anyways, then in 1996, I think it was 1996 or 1996, it would have been. Okay, 1996, I think it was the first time ever the Ontario government and their major union called OPSU went on strike. And I'm not sure there was ever, so this was something brand new for us. And at the Grievance Settlement Board, we set up a process to resolve very quickly disputes about the strike. There were all sorts of rules about picket lines and all sorts of stuff. So you needed a dispute resolution process, which would respond very quickly to issues because it had to be resolved basically that day. So I was lucky enough to be chosen to be one of the vice chairs. And we developed what turned out to be the concept of MEDARB, which is you first try to resolve the matter in typical mediation fashion, but failing that, we change hats and we decide the issue. Now, these were not tremendous issues. These were just little issues that had to be resolved quickly and efficiently. And so that's really where the MEDARB concept came. And OPSU and the government, to their credit, liked the process so much that they incorporated it into the collective agreement. I think it's probably the first time it was ever done, that was the defined process going forward. So I had a lot of experience because I used to sit at the GSB 3-4 times a month on resolving disputes. We also used to, corrections, the Department of Corrections has always been a fruitful place for grievances. And we would actually go do site visits. You go to a jail, or I used to go to a lot of psych hospitals, and we would do 20 or 30 grievances in a day. There's pros and cons to that process. So I became very experienced in MEDARB. Around the same time, the Ontario government brought out the Ontario Mandatory Mediation Program. It was a pilot program in the mid-90s. And what they would do is every third lawsuit, when you went to court, you registered your documents, got a number, every third case would be moved into mandatory mediation. And I was, at that point, I was counsel. I was the lawyer for either employers or employees. And so I had my first taste of being an advocate in a civil mediation as opposed to in a labor. And I also find that very satisfying. But I was also very jealous because I wanted to find out what that person at the end of the table was doing. And the first mediators were government employees. They were appointed. Michael Silver was one of the first ones. He's still doing mediations, actually a very good friend of mine. He was one of the first employed mediators. So, and that developed a model which we basically use in civil cases now. It's the 3-hour model with mediation briefs and all that sort of stuff. And I really liked it. I was getting fed up being a lawyer. I'd been a lawyer for almost 20 years at that point. Most lawyers do get fed up, sometimes well before 20 years. And I started, I do the mediation, and then I would take the mediator out for drinks. And why'd you do this? And why'd you do that? And how could I have done this better or whatever? I took a bunch of courses, and then I started practicing mediation in my own world. And so by 2000, I dropped the law practice and became a full-time ADR practitioner. And I've been doing that since 2000. I do about 150 to 175 cases a year. Most of them are half day. And it's a fantastic life. Way better than being a lawyer. I used to have this little thing here. All right, now people always would ask me, what do you miss about being a lawyer? And I would go, nothing. Thank you. And I would give them a litany of the things that actually, that's when I decided it was a big deal to drop being a lawyer. And I did. I don't know if you've ever done one of these things in your life, the pros and cons when you have to make a big decision. And I put down all the things I liked and all the things I disliked. And every one of my dislikes grew from being on the law side of my practice. And everything I liked was on the mediator side. So the decision was easy. And once I publicly gave up the practice of law, my mediation practice went up because I was no longer in a conflict of interest. It's actually quite difficult, I find, although a lot of people do it, to be both a lawyer and a mediator in the same field. Because, you know, if I'm representing a dismissed employee and I'm taking on one of the big downtown employer firms, I have to aggressively represent my client. On the other hand, as a mediator, I want to be everybody's good buddy. I want to be hired by them. So I felt that conflict and I gave up, but I wasn't crazy about doing and did the other. Any comments, questions?
I think it's Xavier.
Xavier, come off mute. By the way, that was the most popular. I read somewhere the most popular term in 2020 was "you're on mute." Speaking,
I can imagine. I just had a question. I'm very, very new to the whole ADR. Actually, it wasn't until Gabrielle introduced the Pre-Law Society. We had never heard the term, and that was just a few months ago. I'd say about 6 or so months. So we're still fairly new, and unfortunately at UPI, they don't provide any courses on ADR or anything like that. But now, of course, after hearing you speak, I'm just kind of wondering, so as far as like an ADR setting, is there any lawyers that are there to represent, or is it just, for example, you and then the two other?
Well, that's a good question. In my area of employment law, there's always lawyers representing parties. The form of mediation that I mediate exclusively in the area of civil litigation. So there's a lawsuit either started or threatened, and therefore each side has lawyers. That's my particular area. There's a lot of different areas, however, where parties are not represented by lawyers. Depending on mediation is very topic specific. Employment mediations are different than insurance disputes, different than family mediations, different than community mediation. So my experience is strictly in the area of legal disputes, but that is by no means limiting ADR. There's lots of ADR where the parties show up and it's the mediator and the two conflicted parties, be they neighbors fighting over something. Matrimonial mediation is kind of weird to me, but the typical model in family mediation, I think at least used to be, was the mediator would meet with the warring parties without lawyers, and only when they reach the tentative deal would they go back to see the lawyer. So there's a huge variation between different practice areas.
Thank you.
You're welcome. Okay, so I thought what I would do too, that the topic was supposed to be through the years. So I thought I'd talk a little bit about, by the way, how long is this whole thing supposed to last? 1 hour?
We usually do it around like 45 minutes. Max.
Okay, good enough. So I'll keep my eye on the price. Okay. So I thought the other thing I would talk about is, since I've been doing this for so bloody long, I have some perspective on how things have changed, what's got better. Most of it got better, very little that it's got worse, actually. In the beginning, mediation, certainly among lawyers, there's always huge resistance in the beginning. And we still, Sana will know, we're still encountering that resistance. When the mandatory mediation program came out in Ontario in the mid-90s, it was limited because it was a pilot project to Toronto, Windsor, and Ottawa. So if you started a lawsuit in Toronto, you had to go to mediation. If you started a lawsuit in Brampton, you didn't. That has not changed in how many years now? 30, 25 years? It's just ridiculous. And Afsana and I are both on a subsection of the Ontario Bar Association called the ADR subsection. And we've been pushing this time for, what are we in our 3rd year? Pushing, and twice before, when I was actually chair of this subcommittee twice, because 1 year nobody wanted to do it. So I came back. This is about our 3rd time to try to get them to expand, and we're still reaching resistance. So there's a huge institutional resistance, especially among lawyers, to mediation. That's why there used to be this debate about, oh, it's mandatory, how can you force people and everything. A mandatory mediation is you're required to show up at 10 o'clock. At 10:01, if you want to say, get lost, I'm out of here, you've complied with the rules. But it's remarkable when you force people to start the process, they usually engage, and it turns out to be successful. So I can't remember. Yeah. So in the very beginning, because lawyers were so reluctant to do this, they wanted judges to be the mediator. So in the beginning, in the 90s, everyone wanted retired judges. And these poor people who were retired on a $150,000 pension thought it was a good idea to throw their ring in their hat in the ring. So in the very beginning, there was a lot of judges doing it. They quite frankly, most of them were not very good at it because they're judges. I did one mediation in front of a retired judge years ago. I was representing an individual with the city of Toronto, and he was fired for what's called just cause. And he was quite a screw up. I mean, there was a good chance I could have lost that case. And we show up at the mediation. And in those days, we did what's called a joint session. And a lot of mediations still occur that way, where the client and the lawyer and the other client and the lawyer and the mediator are all in the same room. And this retired judge says, just call me George. Here's something. Yes, my lawyer, I'll call you George. And he said, well, Mr. Fisher, tell me what your side of the case is. And I tell him, Ms. Jones, tell me your side. Okay, whatever. And then I said, so Afsana, I have a couple of questions I want to ask about your position, which is perfectly normal. The mediator says, what are you doing? I said, asking my colleague some questions so I can understand her position better. You can't do that. It has to go through me. What the F are you talking about? I was thinking, I wasn't stupid enough to say it. Probably would now. He said, no, we don't do that. We don't do that. And they said, I just want to talk to counsel. Judges don't like talking to real people. They just want to, so throws the clients out of the room. Okay, whatever. And then he turns to me, and this is like 20 minutes into the mediation, okay? He knows nothing about the case other than what we've both told him. He says, Mr. Fisher, yes. Have you made an offer to settle? I said, yes, Your Honor. I previously made one of $80,000. Okay. Ms. Smith, well, the city thinks we have a strong case. We've only offered 10,000. Okay. I think Mr. Fisher's right. You should take his offer. I'm going, this is mediation. This is crazy. Now, for that particular client, it was fantastic. But I left there saying, never using a judge again. So anyways, they're still used somewhat. There's a few retired judges, mostly in the commercial world. It's rare in the employment world to ever use a retired judge. So that's definitely been one trend. As lawyers get more comfortable with mediation, and quite frankly, when mediators get better. I mean, we were all babes in the woods in those days. Half the time we didn't know what we were doing either. But as more and more mediators are better at their jobs, judges have just had to go home and suffer on their pensions.
Can I just interrupt for a second with a
Sure,
question?
absolutely.
So talking about how you would never, pick a judge again in this scenario, what kind of qualities do you think people should look for when they consider a mediator or arbitrator?
Well, okay, that's a very good question. Mediation now has become, certainly again, I speak from my Toronto experience. Okay, so it's Toronto centric. Just like it's very hard to be a generalist as a lawyer these days because the law is so complex and competitive, it's difficult also to be a generalist in the mediation field. So I think one of the things that a person looks for in a mediator is what I call product knowledge. In the old days, we used to say, no, it's all about process and you can mediate everything. That hasn't turned out to be the way it really works out. Most mediators, you have to choose some area. You can't go from family law to employment law to insolvency law overnight because you're a jack of all trades and whatever. So people are looking for product knowledge. Another big deal is there's this endless debate about what is mediation. Is it what's called facilitative or evaluative? And it's a continuum. The purely facilitative mediator would never render an opinion, believes the litigant, the participant has the best ideas and is really there as a process engineer. An evaluative mediator, which I am, brings their understanding of the law and human interactions and negotiation theory and all that actively into the process. So some people say, I want to have an expert who's going to help evaluate, and other people say that's the last thing in the world I want because my case sucks, and I don't want somebody telling me my case sucks. Ease of dealing with the person. You know, I tend to have a very informal style. This is me. Sometimes that works. Sometimes people don't like it. It's important that the lawyers, you don't have to be friends with the mediator, but you got to get along with them. You got to respect the mediator. You're hoping he or she's going to be honest in their back. Most people ask around a lot. I mean, some people look at other characteristics, gender, ethnic origin, things like that. I know that's a big part of this. I tend not to think that that's important. I think we all can understand. You don't have to be in the same shoes as another person to understand where they're coming from. And quite frankly, it's rare that both parties in the dispute are of the same gender and ethnic background and all that stuff. So when you're saying, well, you know, if a female brings forth a sexual harassment complaint, only a female can understand it. Well, the mediation has two sides to it. So the male harasser, he also has to have someone understanding. So I personally don't think it's as important as sometimes that aspect is played up. You have to have a good understanding of people. You have to be able to understand where people are coming from. And I hope that I do. I ask a lot of inquiring questions, which at first may sound obnoxious, but you find things out about people that you can use later on in the mediation. Cost is an issue too. Some mediators are way more expensive than others, and you have to decide whether that's worth the value. So there's a bunch of factors that go in. You should always choose me. That's simply the analysis that I always use.
Thank you.
Now, for instance, I only do litigation disputes. There's a whole nother world of employment mediation, which involves not the dissolution of the rest of the employment relationship, but trying to rebuild a fractured relationship. So, you know, typically following say a workplace investigation, restorative mediation is a whole bunch of different terms where people come in, work with groups of people so they can start working together again, as opposed to threatening each other and filing complaints against each other. That's not my area of expertise at all. I did it once. It was a disaster. I was hired by the company. They had two competing executives and they couldn't get along. I was hired, so I tried it out. At the end of the day, the only thing that worked was I said, if you guys can't figure out how to get along, I think the boss is going to fire both of you. So that caused them to change their behavior. But that's a whole nother area of mediation, completely different skill set, one that I don't possess at all. So. All right, so there's the judges thing. I kind of got into that in the beginning when I first took training for mediation, which I'm always proud to say I took at Harvard. The only reason I went to Harvard for the course was so I could say I went to Harvard, because we intimidated Canadians. I knew if I took a Canadian course, big dude, oh, you went to Harvard. It was actually the worst mediation course I ever took. It was quite funny, but I did get socks out of it and thing. So I took a week course there. I took a really good course in Washington by these two, Singer and Lewis. I don't know if they're around anymore. They were a husband and wife team. They were fantastic. That was really good. We, in fact, our mediation was, why try to mediate something small? Our mock mediation was solving the Middle East crisis. We did it in 2 hours. I don't know why the parties took 50 years. We actually resolved it in 2 hours. So, and then I took a bunch of courses in Canada too. They're somewhat useful. I don't know how they teach it now. I had already been doing mediation in the labor relations world, so I wasn't new to it. And I found a lot of the teachings just didn't make sense to me. I don't know how they teach it these days, frankly. But a lot of what they teach in the mediation courses, I didn't find that helpful. Most of the teachers and most of the writing, certainly early on, believed as a matter of diligent faith that facilitative mediation was the only mediation. And to actually render an opinion was horrible. You're not a judge, whatever. And I just found that not to play out in the real world. So and over time, those mediators who claim to be totally facilitative have not done as well economically as people who claim to be more evaluative. So I think that there's been a trend towards evaluative specialist mediators, because the debate used to be, well, do you want someone who knows employment law or do you want someone who knows mediation? And the answer is, I want both. I don't have to choose. It's a false dichotomy. I want someone who knows the product area and knows mediation practice. God, I should improve my writing. Yes.
Could you tell us the difference between an evaluative mediation and a mediation proposal?
Okay, that's an Americanism that I'm seeing a lot of these days, actually. A mediator's proposal, very popular in California. It flows from being an evaluative mediator. I think that's usually the way I hear it. What happens in a mediator's proposal is the parties negotiate, or frankly, I think pretend to negotiate. They reach a stalemate, and then they ask the mediator, well, would you give us a mediator proposal? In other words, would you do the hard work because we don't want to? Will you suggest a number or a resolution? And hopefully that will get both of us to agree to it. Very common in California, for instance. I have my own view of it. I don't think it's a great idea. I think the lawyers get lazy and the clients get lazy. If I know that you're going to make a suggestion and I'm going to be morally bound to accept your suggestion, then I'm going to hold back on my negotiations. I'm not going to really give as much. It detracts from the whole purpose of the mediation, which is to make the parties agree, and it looks more like a judge, like a trial. Evaluative techniques is a technique. It's not suggesting the answer. So in a classic if this was an evaluative mediation, I might say, Xavier, you've probably got a difficult argument before a court. Moreover, for you to win, you have to win 3 successive arguments. You have to pass those 3 things. So, you may have difficulty because the other side has told me there's the case of Smith and Jones, and what's your opinion on that one and everything. But I never say, but that's giving my opinion. And they usually ask for it, frankly. They hire you because they want your opinion until they don't like it. And then they turn on you. But you have to be careful how you do that. I blame the other side. I say, well, the other lawyer is arguing this argument. What do you have to say to that? So
I had a question.
Sure.
Just the more you speak sounds really interesting. And I'm certain that other individuals here find this very interesting as well. So I was just wondering, so if you were to as a pre-law or whatever, right, what would be the best route to end up in the same position as a mediator? Would you have to go to law school, or is there a different degree or different courses to take for that path?
The overwhelming number of successful mediators are lawyers who have practiced law for a significant period of time. There are exceptions to every rule, and there's some very good mediators who have not done that traditional route. 2 in question that I know very well. They had some help from their father because he's an experienced mediator. So unless your dad is a mediator, that route's gone. There are a few people who have done extremely well, but they're few. And honestly, in the world that I'm in, which is mediating civil legal disputes, it's not a route for success. That's having said that, other areas of mediation do not involve the same degree of legal careers that, like family, at least community, things like that, they don't require to be a lawyer. And not only that, when a first-year lawyer says, I want to be a mediator, I'll say, well, come back in 10 years. It's not a first career for most people. You will not have any credibility with the parties. You have to be able to, helps to tell some war stories and stuff like that.
So in a way, it's similar to like if you want to become a judge, you need to practice law for a certain amount of years, and then
Yeah,
you
that's
can
a
go to-
statutory requirement of 10 years, but yes.
Okay,
Like medical students should not perform heart transplants.
right.
Even
That
if
makes
on
sense.
Grey's Anatomy, they can.
Yeah.
My wife and I are into Grey's Anatomy. We didn't know it existed for years, and then we've been on this binge. So anyways, yeah, there's a lot of, when I talked about mediation courses, there was a lot of money being made by mediation course conductors. And there was a lot of disappointed people who thought they'd take a 40-hour course and change careers, and it didn't. So it is a very, very tough field to break into, which is one of the reasons we on the OPA subcommittee have been pushing to expand mediation throughout the province, because that would overnight increase the number of available opportunities, I don't know, 5-fold or something. But it's very competitive. It's very hard to break into. Okay, the other thing that has changed over the years is shorter introductions. When it used to be, we took these mediation courses and they were doing 20-minute intros. Hello, my name is Barry Fisher. This is what the process looks like, blah, 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 blah. And the mediator would never shut up. You know, I used to do that because I learned how to do it. And I remember doing one with this really nasty piece of work employer. He was just a prick. And we're in a joint session, all in the same room. And part of my spiel was, you know, I mean, we're here to try to reach a compromise. Oh, that was them were fighting words for this guy. He stands up over the table, sticks his finger right virtually in the plaintiff's eye and says, I'm not going to give you a fucking dime. Well, let's build on that. You know, so my intros have become shorter and shorter and shorter. Now my intro is, hi, I'm Barry. I got a question for you. But so I think introductions across the board have become shorter too. Again, in the beginning, you were often dealing with lawyers who had never done one, but now all lawyers know about mediation, and frankly, half the institutional clients, they know about it too. The insurance adjuster has probably done more than you. So frankly, I rely on the lawyer to tell his client what the process is. Not my job. Partly because, as I say, when the mandatory mediation program came out, it was just arbitrarily designed to be a 3-hour process. It has turned out to be quite successful, at least in employment law. Again, most mediations are scheduled for a half day, and we get them done in 3 hours, 4 hours. Frankly, if you give somebody 8 hours, they take 8 hours to get around to making tough decisions, you know? So you can't do it in an hour. 8 hours, they look at their watch and say, I don't have to get serious till 4 o'clock, and you jerk hours. It seems to be a good combination of time. So we're doing them in much shorter periods of time. Early on, one of the first mediations I did was with 2 very experienced lawyers. One of them you might read about occasionally, Howard Levitt. He's in the newspaper all the time. And the other one was Randy Eklund, who became a judge and unfortunately is now deceased. But this was early on. It was a fairly big dollar case, but we started at 10 in the morning and we went till 2 in the morning. Sorry, 10 in the morning of Thursday and went till Friday morning. Little side story there. This was before we had cell phones. And didn't even have a pager. I was supposed to play hockey that night, so I skipped the hockey game. And then I was midnight, and at 2 in the morning, my wife shows up at the mediation, comes down from North York, talks to the security guard in my building to letting me up. And she looked at me and basically said, I'm not sure you're alive. I'm not sure I'm glad you're alive because I feel like killing you. She had no idea what happened to me. She left my poor son, Matthew, who's now 40. He was all of, I think, 8 then. He left him at home. He talked to the police when she called the missing persons report. But her presence at 2 in the morning brought the parties together and we got it resolved. Shortly after that, I bought a pager. So we're definitely periods of time. We're more efficient. Zoom has changed everything too. We had to learn Zoom basically on March 15th, 2020. I didn't know what it was before. I never heard of it, never would have believed in it. Online dispute resolution, that's ridiculous. You got to be there with the person and all that. Well, that was going out the window. And we all became quite astute at Zoom very quickly. And I've done 2 mediations face-to-face since then. So this is the world we live in now. It's a great world. I get up at 9 o'clock. I have coffee. I have breakfast. I put on shorts and Crocs. I do have a shirt on. And I'm downtown in my office, which happens to be in my home, in 2 minutes. No more traveling. I added up once. For 40 years, I commuted. I spent an hour and a half a day. Is like three or 4 years of my life was spent on Bayview Avenue, waiting for the light to change. So Zoom has been an incredible advantage. It's lowered costs for everyone. It's people are much more comfortable. You're a 62-year-old person with a high school education. You've been fired from your job. You live in Pickering. You're terrified to go downtown. They never want to go downtown, people in Pickering. I understand why. I can't stand it now anymore myself. They're intimidated by the large boardrooms. Everything's intimidating. Now they're sitting in the living room, patting their cat. Or I love the cat. Don't you love when the cat goes across the keyboard of Sana? There's always people, all cats seem to love walking across things, or they bring their kids. People are more comfortable. The employer doesn't have to fly in from Texas. The guy's on Zoom. It has been a huge, huge advantage. And I don't think we're ever going to go back. Certainly hope not. I gave a seminar today, a face-to-face seminar, which is fine. I still like to see people occasionally. I had to put on big boy pants and socks and shoes and everything. It was terrible. But a tie, forget it. I haven't worn a tie in 20 years and no one's making me put a tie on again.
Sorry to interrupt. I think we have a question.
Oh, sure.
You want to go?
Hi. So you say that you miss nothing of being a lawyer,
Right.
and that a lot of
The fees, I do
get
miss the fees.
tired, and a lot of people do get tired of it over time. Like, what traits do you think the people who get tired of being a lawyer have in common? Like, once you're already
the things I found aggravating about the practice of law, maybe that's the easier way. It sounds weird because I live in a world of conflict, but I don't like personal conflict. I abhor personal conflict. I am the biggest conflict avoider in the world. My wife wouldn't agree with me. So being a lawyer, you're often in conflict with your own client over fees, over how he's doing. You're often in conflict with the other lawyer. I mean, that to me was one of the biggest stresses. There's a lot of, can I use this term, assholes in the legal profession. Probably I was one half the time. And it's very aggravating. Every lawyer in the world has a list of 3 people he hates having to deal with. I found that very stressful. The time frames stressful. The demands on the client, the deadlines, you're always behind. It's like never, it's like like your guys, a lot of you guys are in school, right? There's always some papers outstanding. There's always 50 papers outstanding. You never, ever clear your desk. You've never returned every email. You're always just a few minutes, you're always worried that you were negligent and stuff. It's very stressful. So, but the fees are better.
Hi, my name is Sarah Collins. I just have a question for you.
Mhm.
Based on just kind of what you've been saying and how you don't really like conflict and whatnot.
Personal conflict. I want other people's
personal
conflict.
Would you would you ever be interested in becoming a judge yourself?
I thought about it at times. I don't think I have the temperament for it. You have to be way more patient than I'm capable of. And I just like to get involved in the fray. If you go to a trial, if you've ever seen a real trial and you've watched something on TV, there's no comparison. They're slow, They drag out. It's not the way anybody would talk. You have to ask questions in a certain format. I understand all the reasons for it, but it's just so dragged out and slow. So I thought about it at times. I would have had to take a pay cut. And to be a provincial court judge wouldn't have been satisfying. To be a superior, local connections. I have friends who became judges and they just sucked up to the party in power, and then you hope that they win. You spend years courting the Liberals, and then, God damn it, Harper comes in and you're screwed. So, and you know what? Judges have to do a lot of different things, and I find most law deadly boring. I love employment law. I've been doing it for 42 years, and I still love it. It's human beings. To sit there and have to listen to a 3-week closure, I'd slit my
Yeah,
throat.
thank you.
So I don't have the patience for it.
Hi, my name is Amritpal Kaur. And I have a question for you
Oh,
that,
there you are in the corner. Okay, yes, hi.
yeah, have there been any chances, like if you have done like mediation and parties are not able to reconcile, or the dispute hasn't been resolved, and they move over to arbitration, which is MEDAR,
Yes,
and isn't that the arbitration the same process as the litigation? Like,
it's similar to
you,
litigation. Okay, that's an interesting question. So you've got a med-arb, and you're right, you do the mediation first, and then the mediation fails. Now, classic med-arb is, and I get upset when people get these, med-arb is the same person being the mediator and then the arbitrator. But to use your, so you try mediation first. If that fails and it went to arbitration, your question is, what is the difference? Is that just like litigation? What's the
yeah, and
difference between
also the
litigation and arbitration?
yeah, and also that is also my question, but also one thing, is there any chances that confidentiality clause get harmed in arbitration? Get
An arbitration is ruled by what's called an arbitration agreement, which is a contract between the parties and the arbitrator about how they're going to conduct the arbitration. And one of the features of arbitration is that parties can't agree to keep the whole process confidential. You can't do that in a court case. Courts are open. It's very, very difficult to have anything but an open trial. The public's allowed to go there. Everyone reads the decision. But yes, the parties can contract, and they often do, for the contract to keep the whole process confidential, the decision confidential, the evidence, everything is not open to public viewing.
Oh.
Now, that has been criticized in the past too, because like in the US, for instance, it's very common in the US that employment agreements have mandatory arbitration clauses, which means that the horrible things that employers have done remain buried. So there's some controversy about that. Is that fair? It allows the wrongdoer just to keep on doing it and pay this person off, blah, blah, blah. But generally speaking, that the parties can contract to have confidentiality. Okay. That's, again, one of the huge advantages of arbitration. The parties can decide their own process. They can decide whether they're going to limit examinations of discovery. They can define the issues. They can contract out of the right of appeal. Arbitration is a very flexible model designed by the parties to fit their dispute resolution needs.
Mhm. Thank you.
You're welcome. Okay, so where was I? Blah, blah, blah. Yeah, I think I said this already. One of the changes I've seen over time is lawyers are much, much better. In the beginning, until the mediation and a court case, they would just make it sound the same. Now they know they're there to settle. So they still bombast and stuff like that, but they're more focused on getting a resolution than arguing the case in court. Another big change, again, in employment law is traditionally we had what was called a joint session. I think I chatted a little bit of this, where the two lawyers, or the lawyers and the parties and the mediator are all in the same room, and typically each side would present some aspect of their case. I found that process to be a complete freaking disaster. every mediation conference I ever went to, when mediators talked about the joint session, they would exchange horror stories about how it blew up, like the example I gave you of the guy pointing the finger. In employment law in Toronto, at least, it's virtually extinct to do a joint session now. It is still very common in personal injury mediations, for instance, and in commercial mediations. So in typical personal injury mediations, you're there, you got the injured party or the allegedly injured party sitting with their plaintiff's lawyer and the mediator at the end, and then the insurance company with the insurance adjuster there. And the plaintiff will start off saying how horrible her injuries are, blah, blah, blah. The patient, the plaintiff will probably read from a little script about how horrible her day is. She's in aches and pains. And then the insurance company lawyer will turn to the plaintiff, I love, and say, I'm not sure, Mrs. Smith, can I call you Mrs. Smith? I'm not sure, Mrs. Smith, whether your lawyer actually told you about the weaknesses in your case. So my job is to help you understand, because we want to help resolve this. And I want to gag with a spoon. So, and when I used to have joint sessions, I never forget, and it's fun. This old guy who was like, was my age, and he was like real rough, like an Archie Bunker type. They've been there for 40 years. And I said, so how long have you been with the company? 35 years, 6 months, 3 days, you know, like real. Anyways, and he's talking about how horribly he was treated and all that. And that's fine, we're listening. And then I said, well, let's go to separate caucus. And then the HR person, who must have been under 30, said, hold on, Mr. Fisher, don't we get to speak? I said, oh, you're right, I'm sorry, I forgot. So then she starts to tell him about how, because the company's debt equity ratio has been off and dividends are down, they had to lay him off. And I'm going, no, this is. So I pulled her out in the hallway. I said, the company's not the victim here, okay? He doesn't want to hear about your financial goals not being achieved. He's lost his job, for God's sakes, just shut up. So anyway, we used to waste a lot of time on joint sessions. They still do in some areas, but one of the trends now is not. And plaintiffs, I've never met a plaintiff yet who wanted to do a joint session. Never. I changed about 10 years ago now. It used to be the default rule to always do a joint session unless the party said otherwise. I just changed that on its head. I said, I'm not doing a joint session unless both parties wish. And since that time, I had one group who wanted to do a joint session, and the case didn't settle. So that's been a big change. Again, that's not universal. None of the things I say are universal, other than people are getting better at their jobs. The other thing that's happened is, and especially in Toronto, lawyers go right to mediation. All the boring steps that we used to do, pleadings, discoveries, affidavit of documents, motions, pre-trials, all that crap. Now, sometimes they issue a statement of claim and a statement of defense. Sometimes they don't even bother. They go right to mediation. Because again, in employment law, most of the issues are known, or if you have to know a little bit more, you find out at the mediation. Ask a question. Okay, there's your answer. You don't have to do discoveries to find out what the answer to the question is. So the parties are able to resolve the matter much quicker. The typical case I have, the person was fired 6 months or less. That's very, very fast resolution in the legal system. And people haven't incurred sunk costs in litigation. So they could use the money they would have. And then I can say, well, I say to the lawyer, well, if we don't settle today, what are your costs going to be in the future? And that scares the crap out of each side. And they'd rather use the money to settle. So that's another positive experience.
So I'm so sorry to interrupt.
Yes.
It's 7 o'clock. So we're happy to
Okay.
keep listening as well, but I just wanted to let you know in case you.
Yeah, no, I was actually perfect timing, because I can't even read the last thing on my list. So you've been more than patient, and it's been a lot of fun. So
I've been enjoying it. Thank
hope
you.
So not everyone, ADR is a very broad aspect. You don't have to be the neutral. if you go into the practice, like I assume a lot of you are, when you say it's a pre-law program, I'm assuming a lot of you are wannabe lawyers, right? So most of your experience will be as an advocate in ADR, and that's extremely important too. And everything I've said applies to being a good advocate in an ADR, which is different than being an advocate in court, but not totally different. You're there to represent your client. You're there to get the best deal. It's just in a trial, you don't care about the other side. You're trying to influence the judge. In a mediation, you're trying to influence your opponent. So it's a different technique because the target of your persuasion is different.
Sorry, I have one more question.
Sure.
Like when I was doing my course, like in my second semester, we used to have the role plays. And when I had the role of mediator, sometimes it's the questions that parties feel that I am being impartial. So even if we are not being impartial, still they feel that like my questions were hurting them. So how do we manage our emotions?
This sounds so topical today. Mediation is not providing a safe space. I get you here. Being impartial means doesn't mean not having an opinion. Being impartial means you start off from a premise of no bias. As you hear more and more facts of the case, of course, you're going to start forming an opinion. And expressing your opinion is not bias. Like if you listen to the case and you realize one side is completely full of it and they're never going to think, that's not bias, that's your opinion. Bias is starting off by saying, oh, Xavier, that's kind of a weird name. I knew a guy named Xavier, I couldn't stand him. I can listen to him. Learning as you go along and forming an opinion, expressing that opinion in a certain fashion is not bias. And they're just trying to scare you off. They're trying to influence you. Bias now means you don't agree with me.
Yeah, and like one of the parties said me that you're taking the sides.
Correct. Right.
Okay, no, I'm not.
So here's one of the ways to deal with that.
I'll rephrase my question then.
There's I get that all the time. So for instance, well, first of all, is this in a joint session or are you just meeting with one group? Has this come up just in one group? When
No,
you meet with one side?
It was a joint session.
Okay, so that's another reason I don't do joint sessions, okay? Because anything you ask in a joint session will be appearing to help or hurt someone. So another good reason not to do a joint session. And asking difficult questions in a joint session is almost impossible. So the answer there is don't have the joint session. And then when someone says, like someone, I'll be, I kind of do a Jekyll and Hyde routine sometimes. I'll start off really nice and they like me and then I whack them later on. But, oh, but you used to like me. Yeah, but your argument sucks. So now I'm giving you the real world. It's much easier to do in a separate caucus, in a separate meeting. And if you say, well, you know, I think you're biased. I said, no, I'm reality testing, okay? I'm asking you questions very nicely. You ought to see what it's going to look like when the other side asks you that question. And there's some tough questions. You've got problems with your case. It's not a slam dunk. No, neither's the other guy. And sometimes I'll say, listen, I'd rather be the lawyer for the other guy. He's going to make more money than you are. But you have to have confidence in saying that, and you have to build up. You don't do that right away. In the beginning, you're just obtaining information. And then later on, if they respect your opinion, and yes, I'm sorry you feel that way, but this is an important question. And, you know, or I'd say, fine, do you think I'm biased? Fire me right now. I'll go home. Oh, no, I just want you to be on my side. And then sometimes when I'm really, like I'm harsh on the side that I think is wrong, okay? Like it's a stupid argument or they're being too cheap or whatever. And sometimes the client will say, well, you're really being harsh. And the lawyer will say, don't worry, he's being the same in the other room. And I say, no, I'm not actually, because they're being reasonable. You're not. Why would I beat up on everybody? And they make a joke about it. So it's like, no, they're being quite rational. You're not. So, oh, geez, I thought you were doing the same. No, no. Don't beat up on someone who's being reasonable. Use your compliment them. You really got to be able to read. You got to know the law and all that crap, but you got to know people. You have to understand people, and you only got 3 hours. You don't know a lot, so you have to rely on human experience. What's their point? And the more you do of the same, the more you realize, yeah, people are scared. They're scared. They get reactive. You have to learn. One of the toughest things to learn is, and this is hard for me because I know it sounds weird, but I actually generally believe people are being honest with me. It's not that they're lying. Like someone will say, what's my bottom line? Whatever. They may even believe that at the time, but you can't take them for their word on their positions because they're flexible things. Like, why is that? Like, I'm never settling for less than $100,000. Okay. So if I brought you an offer of $99,900, well, of course I'd say yes to that. Then it's not a bottom line, or I don't need a bottom line. So you learn these little things. People, the most difficult, my last comment, unless you want me to keep on going. I charged $2,800 for a 3-hour mediation. So what is that? $900 an hour or something? It's not. I charged $800 for the first 2.5 hours, and I charged $2,000 for the last half hour. In other words, it's a joke. You're paid. The closing is the hard part. It's kind of like being, you either have a deal or you don't have a deal. Now, are there mediators that say, oh, there's no such thing as a failed mediation? Yes, there is. I just paid $2,800 and I still have a lawsuit hanging around my head. That's a failed mediation in my book. You might get close, but what is it? Close only works in hand grenades and horseshoes or something like that. Now, that's not completely true, actually, because if you bring the parties closer to mediation later on, they might settle and stuff. But I try to make them, I said, these are difficult decisions and all sorts of stuff. Closing the last half hour is usually the most difficult. And there's all sorts of techniques. You learn them over time. Sometimes they work, sometimes they don't. We settle. I think the overall experienced mediators seem to resolve around 80%. That seems to be a common number that I hear from people, at least again in employment law. I think in insurance it's lower because they're crazy. They make stupid offers and whatnot.
That's amazing.
Thank you.
Thank you so much for taking so much time with us and for answering our questions. I know, like myself, I've learned so much. So thank you so much for everything. If there's no other questions, I think we'll end it here.
So can I ask you guys some questions? So that this you meet every couple of weeks or something, and you always have speakers, or what do you guys do? What is this student committee?
Yeah, for sure. So if you'll just pause this.